Hello, beautiful light-skinned ladies. This is Dolce K, and today we're going to talk about some history in the 1990s or in 1989. Some very surprising, shocking history. And I may put this video in a playlist and title that playlist Crimes Against Black Culture or Crimes Against Black History, because when you see what this is all about, you're going to want to know why this wasn't taught in Black history. And you're also going to want to know why this wasn't discussed in conversations about colorism. But before I get into this, I do want to remind you guys about the initial colorism definition. Initially, it was established by Alice Walker, the author of The Color Purple. And in her definition, there was no qualification of which way it went or which basically just described or defined as skin tone discrimination within the same racial group. Okay? So here in the United States, we have laws, thanks to Title VII, that protect us from discrimination based on our protected statuses, such as age, gender, if you're a caregiver, your race, obviously, your national origin, and then there are subcategories underneath all of those as well. So, for example, natural hair or your hair texture would be considered as a subset of national origin or race and national origin. There's also another protected status, that one being color. And color is different from race. So color refers to literally your skin tone, okay? But it used to not be differentiated. It wasn't always differentiated from race until this case right here that we're going to look at a short synopsis of. Walker v. Secretary of Treasury, IRS, and this took place in the Northern District of Georgia in 1989. So let's see what happened. This is about a woman named Tracy L. Walker who took the IRS to court. Okay, so let's get into the facts. So the person who is filing this suit, her name is Miss Walker, and she was a permanent clerk typist in the Internal Revenue Service's Atlanta office. Miss Walker is a light-skinned Black person. I'm trying to say it like that girl in the video. She was a light-skinned woman. Yeah, she is a light-skinned Black person. Her supervisor was Ruby Lewis. Miss Lewis is a dark-skinned Black person. The employees in office in which Miss Walker and Miss Lewis worked were predominantly Black. And so I think this is very important because do you remember in the colorism video I did where I showed a clip of the girl that was saying that, you know, colorism exists in the workplace, white people are going to treat you better if you're a light-skinned Black person. And she was pretending as if there weren't Black people in power that can discriminate against each other. So this case literally is proof that it happens, that, same race discrimination does happen. And in fact, the definition of colorism is inclusive of same. It's limited to same race discrimination. So I don't understand why she was talking about what white people are doing, because that has nothing to do with colorism. In fact, following her termination, Miss Walker was replaced by a Black person. So this is very important because remember, at this point, there was no differentiation between race or sex. I mean, race or color. According to the record, the working relationship between Miss Walker and Miss Lewis was strained because, or from the very beginning, that is, since approximately November of 1985. Miss Walker contends that Miss Lewis singled her out for close scrutiny and reprimanded her for things that were false or insubstantial. So for 4 years, this woman was being singled out and closely scrutinized and reprimanded for things that weren't even true or that were petty. Ms. Walker's relationship with her former supervisor, Virginia Fite, was a cordial one. In fact, Ms. Walker received a favorable recommendation from Ms. Fite. So it sounds like the only person who Miss Walker is getting any kind of negative feedback from is this Miss Lewis woman who is her supervisor. But before that, she had another supervisor, and she received favorable recommendations from that former supervisor. Okay, so Miss Walker met with Sydney Douglas, the EEO program manager for the Internal Revenue Services Atlanta District, about the problem she was having with Miss Lewis. And if you don't know this, I'll let you know now. If you believe that you're being discriminated against, you need to go to your EEO program manager. Every business is supposed to have an EEO program manager. EEO stands for Equal Employment Opportunity. So if you feel like you're being discriminated against, that is the first step. You have to speak to the EEO program manager or speak to HR. But remember, HR is not really there to protect you. HR is there to protect the company. The EEO counselor and program manager are there to protect you, right? Okay, so 2 weeks later, pursuant to Miss Lewis's recommendation, Miss Walker was terminated. Oh my goodness. So 2 weeks later, after after yeah, 2 weeks later after Miss Walker met with the EO program manager, she was fired. Yeah. And I can tell you, as someone who like does work in this industry, that's called reprisal. You can't like fire someone 2 weeks later after after they engage in a protected activity, such as going to EEO, or if they, became pregnant, like you can't fire them 2 weeks later. Anyways, the reasons given for her termination were tardiness to work, laziness, incompetence, and attitude problems. It is Miss Walker's belief that the reasons were fabricated and were the result of Miss Lewis's personal hostility towards Miss Walker because of Miss Walker's light skin. So basically, she's saying that no, none of this is true. I am not tardy to work. I'm not lazy, and I'm not incompetent. She's just fabricating these stories, pulling this fake narrative out of nowhere. Um, and it's because she doesn't like me because I'm a light-skinned Black woman. Miss Walker has not presented any direct evidence that Miss Lewis was prejudiced against light-colored skinned Black. So let me explain to you guys what that means when they say direct evidence. So direct evidence would basically mean if she made a comment like, oh, you light-skinned Black women are so lazy. You light-skinned Black women think that your pretty privilege is going to solve everything and you don't know how to do real work. So direct evidence would be like a comment that was explicitly stated. It could have been directed towards her, or it could have been directed towards someone else, or she could have just been having a conversation. But if she said anything negative about light-skinned Black people, that would be considered direct evidence. But that did not happen. So they're not saying that she doesn't have any evidence. They're saying that she doesn't have that type of evidence. There's other types of evidence that you can present. And that's what they're going to talk about next. So there is evidence that Miss Lewis might have harbored resentful feelings towards white people, and therefore, by inference, possibly towards light-skinned Black people. So I can give an example of this. When And I've seen this like in other Black women empowerment spaces or other Black spaces here on YouTube, and they're like are talking about a Black man who is fetishizing his woman because she has light skin. uh and if she's white, they'll start making comments like, oh yeah, they always go for the pasty bunch. So if they're calling those people pasty and you're light skinned and you're like fairly light skinned, but you're not white, you're still Black, what makes you think that they're not going to refer to you as pasty behind your back? So that's basically what they're getting at here, that she has openly made comments about white people. It sounds like possibly she made comments about white people that were regarding their skin tone or their complexion. I would bet money that she was making comments or had showed her resentment towards white people by making comments about their complexion. When people joke about, what white people are going to do when global warming takes effect and the sun is like too hot and that, they're going to burn because they don't have any melanin to protect them. Those types of statements. I'm betting money she said something similar to that. Possibly towards light-skinned Black people, therefore, she might have possible resentful feelings towards light-skinned Black people. Miss Walker maintains that she was treated unfairly prior to her termination for no apparent reason. She would have the court infer that the unfair treatment was due to Miss Lewis's prejudice of her light skin color. Following her termination, Miss Walker filed this lawsuit pro se pursuant to Title VII of the Civil Rights Act of 1964. Okay? And the Administrative Procedure Act. Okay. Walker alleges she was terminated because of invidious discrimination on the part of her supervisor, Lewis, and that her termination constituted retaliation, yes, retaliation, reprisal, due to her complaining to the EEO. That's exactly what I was saying earlier. So, due to the fact that this is a Title VII action, the case was a motion with respect to the claims under 1981, 1982, and the Administrative Procedure Act. So this was with respect to what was in Title VII at the time that she filed it, 1981 and 1982. And remember, at this time, race and color were not necessarily differentiated from one another. Okay, so now we can get into the legal discussion. So the Title VII discrimination claim, that is the principal issue in this case, and it is novel. It's kind of new. Does a light-skinned Black person have a cause of action pursuant to Title VII against a dark-skinned Black person for an alleged discriminatory termination of employment? Or in other words, are light-skinned Black people discriminated against by dark-skinned Black people in the workplace? And does Title VII protect them from that discrimination? The defendant offers two reasons that there should be no such case as cause of action. First, the defendant contends that although Title VII includes color as one of the bases for prohibited discrimination, that term has generally been interpreted to mean the same thing as race. Yep. Second, the defendant contends that there simply is no cause of action pursuant to Title VII available to a light-skinned Black person against a dark-skinned Black person. So basically, at that time, people were believing that, oh, no, you're light-skinned, you can't be discriminated based on your color within your same, and definitely not within your same race. So, discrimination on the basis of color. So, Title VII is the exclusive remedy for federal employment discrimination lawsuits. Yes. The historical predecessor to Title VII is the Civil Rights Act of 1866. In fact, in a suit such as this one, the legal elements and facts are necessary to support a claim for relief under Title VII are identical to the facts which support a claim under 1981 Lincoln v. Board of Regents. So they're referencing cases where, the facts that you would need in order to prove that, discrimination took place, they're the same facts that you would need in all of these other cases. The stated purpose of 1981 is the protection of citizens of the United States and their enjoyment of certain rights without discrimination on account of race, color, or previous condition of servitude. Okay, so in McDonald versus Santa Fe Trail Transportation Company, the Supreme Court, in an exhaustive study of legislative history of 1981, makes repeated references to the fact that the statute was originally enacted to apply to citizens of every race and color. In what is perhaps the most relevant case of the lawsuit, St. Francis College versus Al-Khazraji, the Supreme Court stated in no uncertain terms that at a minimum reaches discrimination against an individual because he or she is genetically part of an ethically and physiognomically distinctive subgrouping of Homo sapiens. In fact, the Supreme Court goes even further by stating that it is not even essential to be physiognomically distinctive. Right? So it doesn't matter. It doesn't matter what you look like. It doesn't matter what your phenotype is. Like, you're a part of that group. Okay, so he or she can still claim that they were discriminated against based on the basis of race and color, even if their color doesn't really indicate or match with what their race is. Okay, so, and again, yeah, I'm exactly right, because it's saying that Webster's 7th New Collegiate Dictionary defines physiognomic as relating to physiognomy or external aspects, or as we like to say in this space, your phenotype. Okay, so Title VII was amended in 1972 to provide generally that all personnel actions affecting employees shall be made free from any discrimination based on race, color, religion, sex, or national origin. Okay, so the Supreme Court has on at least two occasions stated that the purpose of Title VII is to assure equality of employment opportunities by eliminating those practices that discriminate on the basis of race, color, sex, religion, national origin. Okay, so it's always been the policy of the Supreme Court that the plain meaning of legislation should be conclusive, except in the rare cases in which literal application of a statute will produce results discriminatively at odds with the intention of its drafters. Right? So it's always been understood that, yes, the law is the law, but we're not going to just leave it at the law is the law when we see that the results or what's happening in the real world is exactly what the law was trying to prevent from happening. So just because a law has yet to account for a specific type of discrimination does not mean that it can't be altered to or that you can't make a case that some other form of discrimination that the law didn't account for took place, because then the law would be like, oh, you know what? We were intending for that not to happen. So we need to go ahead and address this. That's basically what they're trying to say. Yet the defendant in the instant case contends in its brief that in Title VII cases, the word color has generally been interpreted to mean the same thing as race. So this is conflicting, this is contradicting, the policy that, hey, legislation is conclusive, but if we see that the results are doing exactly what we intended to prevent from happening, then something needs to be done. And then the opposite of that is, well, color, we always have interpreted as meaning the same thing as race. So, to heck with the policy, to heck with this same race color discrimination, because we've always just been interpreting it this way. But the statutes and case law repeatedly and distinctly refer to race and color. The court is left with no choice but to conclude, when Congress and the Supreme Court refer to race and color in the same phrase, that race is to mean race and color is to mean color. To hold otherwise would mean that Congress and the Supreme Court have either mistakenly or purposefully overlooked an obvious redundancy. So they're basically saying, hey, we have all of these statutes and cases where you have consistently referred to race and color as if they're separate. Now you want to sit up here and act like it's the same thing? Because if it was the same thing, you would have used the words interchangeably. You would have said race here in one instance, then color in another instance. But you're saying race and color, not because they're conjunctive, and it's because they're separate. Race and color. In the English language, when we put and, you're listing things. Okay, And we don't have a language, or in our language, we don't have that, we don't have those kind of grammatical conjunctions that add that conjunctive quality between things. Usually when we want to do that, we create compound words, but we don't have a compound word for race and color. They're just separate. There are other languages that do that, like Japanese. You can, combine two words together, and now all of a sudden they're not separate. They're conjunctive, and it's understood that those two things are going together. But in the English language, we don't have that, and that's because they either made a mistake in how they phrased that, or they overlooked an obvious redundancy. So the St. Francis case has definitely spoken on the subject. We have little trouble in concluding that Congress intended to protect from discrimination identifiable classes of persons who are subjected to intentional discrimination solely because of their ancestry or ethnic characteristics. Such discrimination is racial discrimination that Congress intended to forbid, whether or not it would be classified as racial in terms of modern scientific theory. So, at a minimum, this reaches discrimination against an individual because he or she is genetically part of an ethnically or physiognomically distinctive subgrouping of Homo sapiens. That's clear that a distinctive physiognomy is not essential to qualify for protection. That case that said all of that made it clear that you don't have to look a certain way to qualify for protection against race and color discrimination. A person's color is closely tied to their ancestry, and it can result in being perceived as physiognomically distinctive subgrouping of Homo sapiens. When they say that you're light skinned, so that means that you're mixed, or you're light skinned, so that that means that you have white ancestry, which in turn could become the subject of discrimination. Notwithstanding that proposition, it is not even required that a victim of discrimination be of a distinctive physiognomical subgrouping, a particularly relevant fact to the case at hand. Yeah, so they don't even have to be a part of that distinctive physiognomical subgrouping in order to have been discriminated or be perceived as physiognomically distinctive. So let's say that you don't see yourself as light skinned, but these other people do. That doesn't really matter. The one case that the defendant cites as authority for the proposition that the term color means race is Felix versus Marquez, but that case lends itself to opposite conclusion. As the court in Felix states, color may be a rare claim because color is usually mixed with or subordinated to claims of race discrimination, but considering the mixture of races and the ancestral national origins in Puerto Rico, color may be the most practical claim to present. So basically, they understood that, hey, in Puerto Rico, you have a group of people who are mixed, like they're hella mixed. So yeah, if you're gonna say that you're discriminated against, it's not gonna be on the basis of race, most likely. So while the defendant was trying to use that case to prove that color is separate from race, they ended up shooting themselves in the foot because that case actually showed and proved and demonstrated how color discrimination on its own does exist within people of the same, uh, ancestral national origins. So another case that states specifically that discrimination as to color as opposed to race can be the gravamen of a civil rights lawsuit is Vigil v. City and County of Denver. So this goes on to just list out that there are some cases that show that color discrimination on its own does indeed happen. It has happened in the past within the same race, even, or within the same ancestral group. Okay. So a suit by a light colored Black person was made against a dark colored Black person. The defendant also contends that it is simply not feasible uh, for Title VII to allow a lawsuit by a light colored Black person against a dark colored Black person. The court has already set out in detail above that in some situations, the most practicable way to bring one's Title VII suit may be on the basis of color discrimination as opposed to race discrimination. To further illustrate why the instant action is appropriate under Title VII, it is once again necessary to refer to the St. Francis case. So in St. Francis, a U.S. citizen born in Iraq filed suit in the federal district court against his former employee, alleging that the employer had discriminated against him on the basis of his Arabian ancestry. So the court granted summary judgment for the defendant on the ground that Arabs are Caucasians and that a suit could not be brought under 1981 by a Caucasian against a Caucasian. That's hilarious, you guys. Tell me if you know of the content creator who also says that Arabs are Caucasians and acts as if they are not different ethnic groups. It's funny because it's purely based on geography. But anyways, the case eventually found its way to the Supreme Court. In its analysis, the Supreme Court carefully considered the legislative history of 1981. The court noted that Congress intended that legislation to apply to all forms of discrimination, including acts of discrimination against groups of people, including Finns, Gypsies, Basques, Hebrews, so different types of Caucasians, basically, right? Swedes, Norwegians, Germans, Greeks, Finns, Italians, Spanish, Mongolians, like all different types of ethnicities. It would take an ethnocentric and naive worldview to suggest that we can divide Caucasians into many subgroups, but somehow all Blacks are a part of the same subgroup. There are sharp and distinctive contrasts against native Black African peoples, both in color and physical characteristics. And this is something that I really want to make a video about because people act as if light-skinned Black people are somehow, um, not Black at all or not substantially Black. We also act as if, mixed people have to identify as Black. So this is really important because the judge is pointing out that, hey, we're dividing Caucasians into all of these subgroups, but we're acting as if, people who are monoracially Black also don't have subgroups that you can see in their phenotype that they look different, both in color and in physical characteristics. Okay, so as mentioned above, the Supreme Court has said that a distinctive physiognomy is not essential to qualify for protection. So you don't even have to look different in order to qualify for protection against color discrimination. You don't have to have a particular, because like I said, you may not think that you're light skinned, but that person probably thinks that you're light skinned, or you may feel like, hey, we're all Black, but this person doesn't see that. And it's true that we have different subgroups. It is therefore it therefore is not controlling that in the instant case a Black person is suing a Black person. Yeah, it's not a problem. In another case, this is Sierra v. Board of Trustees, University of Illinois. The court noted that courts should not be placed in the unsavory business of measuring skin color and determining whether the skin pigmentation of the parties is sufficiently different to form the basis of a lawsuit. That goes back to what I was just saying. Like, you may not think that you're light-skinned, but that person who discriminated against you in the workplace probably thought you were light-skinned. And so Miss Walker, she may not think that she's light-skinned. She may just know that the woman is discriminating against her because of being lighter skinned, because she understands that is the perception that her supervisor has of her. This court recognizes, and the court isn't going to bog themselves down or bother themselves with this level of pettiness of trying to figure out, for a better way of saying it, I'll just say this succinctly. The court is not going to uphold the paper bag test the way that the Black women empowerment spaces here on YouTube want to uphold the paper bag test. This court recognizes full well that such difficulties are genuine and substantial. Nevertheless, the court must find that the issue is a question of fact that must be determined by the fact finder. Yeah, and the fact finder is the EEO investigator. So they're going to have to ask all of these questions and do the investigations to find out the facts. And what they will not be doing is measuring skin color. That's not going to be a fact that they're going to find. This court holds, therefore, that the plaintiff in the instant case has stated a claim for relief that cannot be reached by summary judgment. So yeah, we're not going to just go straight to judgment. This needs to have an actual full investigation. Thus, the court sets aside that portion of the magistrate's recommendation that grants defendant's motion for a summary judgment as to plaintiff's title discrimination claim. Reacted to her case. Okay, so let's see. Beyond the scope of the law, Walker v. IRS signified the social and cultural opening of Pandora's box in Black America by calling attention to a topic that was considered passé and taboo within the Black community. And this was only in the mid-1980s. That's only 2 decades from the Civil Rights Movement. And then in 1982, Alice Walker had first coined the term colorism. So it wasn't even a household term like it is today during Miss Walker's time. We knew what it was, and it was something that was very touchy and taboo to talk about. But we didn't really have a word for it until Alice Walker got on the scene. Okay, and I'm sure that this made a lot of people very angry because this is the first case of same-race color discrimination that is brought up to the United States by a Black person, and this Black person is a light-skinned Black person. Okay, so the word of her case spread, and it ignited a debate and a lot of public discourse that was trying to talk about the legitimacy of her claims. And instead of giving Tracy Walker the credit she's due for being the reason that race and color are seen as separate when it comes to understanding discrimination that we face as Black people in the workplace, instead, these Black scholars decided to just sweep colorism under the rug altogether. So in the New York Times, there was an article that featured the story, and a Black political science professor basically stated that colorism is a relic, and we've gone through the whole civil rights movement and the idea that Black is beautiful. He didn't really think it was an issue anymore. He couldn't have been further from the truth. And even though Miss Walker lost her case at the time, she opened the door for other Black people in the future to win their cases. Okay, and I'll show you that really quickly. So, there is a case in 2003 that a server at Applebee's filed with the EEOC because his manager was a light-skinned Black male who was harassing him for being dark-skinned. Okay, and he was awarded $40,000, and the reason being is because they had the ruling from Miss Walker's case from the judge that made it clear that same race discrimination based on color is possible within the Black community. And so what was that ruling that he specifically made? And we saw this in the synopsis, but it wasn't highlighted or set apart so you could easily differentiate it from the rest of the legal rhetoric. But here it is right here. Judge Moy made a groundbreaking interpretation of the law. Okay. Noting the difference between race and color, Judge Moy stated that the statutes and case law repeatedly and distinctly refer to race and color. So we have no choice but to conclude that when we refer to race and color in the same phrase, that race is to mean race and color is to mean color. Okay? Anything else would mean that we made a mistake or that we purposely overlooked an obvious redundancy. And because they're not going to get into the trivial task of, or I guess you can say useless task or concept of upholding a paper bag test or trying to determine, are they really a different color enough? Do they have enough difference in their skin color for colorism to happen? He just went ahead and made this ruling that, color means color, race means race. Those two things are separate. Okay. And, it's also important that, he mentioned that, we have all of these subgroups for white people, for white Americans. So why should we think that black people are a monolith? Why should we ignore that there actually are subgroups of black people and different phenotypes that black people have? And it is different from race. This is what opened the door for all of the other black employees who were able to get a reward, a settlement after being discriminated against on the basis of their skin tone. Well, thank you so much for watching this video. If you enjoyed this content, please let me know in the comments down below, and I will consider making part 2 of this, where we'll talk about why Tracy Walker did not win her case. But the fact still remains that yes, she is a light-skinned black woman, and yes, she is the reason why race and color are clearly differentiated when it comes to discrimination. And it's all thanks to her that there was even a ruling like that to have been made in the first place. Did you know about this? Did your family know about this? Have you heard of Tracy Walker before? I didn't hear about her before until I started doing some more research on colorism. But yeah, I find it interesting that, she was not given the credit that she is due for having the courage and the bravery enough to bring up colorism when to the courthouse when it was such a new concept as far as in the legal and academic setting. No one really knew about it outside of the black community, and even within the black community, as we saw, it was very taboo and passé to talk about during that time. And I can imagine it being even more so if you were a light-skinned black woman talking about being discriminated against for your skin tone. But anyways, thank you so much for watching, and as always, have an amazing day.